What date have you agreed with? 6th of September?
I think she has.
She's not available that day. I don't know when she will.
If it's a mention, Miss Ngunyi can mention for me. I will take the date.
It is a pre-trial, not just a mention.
It's a pre-trial, then let us take the 3rd week of September.
You are awake for 2 weeks?
Yes.
20th
20th.
of September. Mention on 20th of September.
Yeah, and ask the court to review the terms.
Yes, you'll be able to come back. You cannot say you are not able and you have not tried.
I know where we
Let's
are.
try, then
No, it's because I know where we were and what our imagination was. So
I've considered the issues raised by the prosecution and first watching plea for the first victim as well as the defense counsel. The court ruled that this person has the right to bail bond. The court is guided by judicial bonds guideline policy as well as the Constitution of Kenya Article 49. Indeed, the court takes note of the victim condition and in particular Festus Musioka, who is critically admitted in ICU at Nairobi Hospital since 3rd of July. The prosecution was granted time to ensure victims are secured under the Witness Protection Agency. It seems that the process has just been initiated. On the other side, accused person rights cannot be curtailed by slow process by the prosecution. It is noted that after the court gave directions on 23rd of July, it was not until 29th July when a letter was written to the Witness Protection Agency. It is the finding of this court that bail bond times and conditions should be set today, and as prosecution continue to put their house in order. Therefore, accused person shall be released on a bond of 10 million with one surety or similar amount, or cash bill of 5 million, cash bill of 5 million plus one contact person. Accused person should not be reissued with a firearm or returned the firearm used in the incidents until this matter is heard and finalized. Third, accused person is warned not to interfere with witnesses either direct or through proxy. We shall mention this matter in a month's time for pre-trial.
What's the date?
kind of two sureties, 10 million.
One surety. Why would you want two sureties?
It's easier to get 5 million than 10 million.
So you only wake up on 6th of September because 5th is a Sunday.
I will also order that accused person deposit.
The 29th of July, 6 days later. 6 days later. So today they come and tell you they are waiting, I don't know, for responses or something like that, because you can see there is no response attached. Who is delaying this? It is not the accused person. He is waiting for his terms and conditions. They delay this, and let me say this shamelessly, with an intention to delay this process. Otherwise, is there an explanation as to why? There is none. Manzo, Honorable Manzo, my colleague, clearly brings a bill. Shows he has made effort, he has gone to the client, he has seen. But one person, Felix Sanzisa, every time we have been here in court, Your Honor, you have been told she is in hospital, there is a bill. Today you have been told she is being detained. Not one single document, one, has been brought to even show that. Yet they want to rely on this, that she is detained in hospital, and had we paid, should be here today, or maybe should have been released. Your Honor, it does not make any sense. Yet you're being told that there is another witness called David Mbogwa, who is yet to record his statement. If he has not recorded his statement, what does that mean, Your Honor? They cannot come here and tell you they are seeking protection for him because he has not recorded a statement. They don't know what he's going to say. He has not asked for protection. Why are we even having him in the affidavit? That he traveled that country? So we wait for him to come back so that we can get conditions and terms for the accused person? Your Honor, today, that is water under the bridge. You're being told, let them stay in custody until these witnesses are put somewhere. Yet it's not our problem, Your Honor. Respectfully, let me say so. They delay the process, then they come and tell you, please hold him until they are able to put their house in order. The fundamental rights belong to this accused person today, Your Honor. Not only the victims. They should not come here and keep on crying at the expense of saying that the accused person stays in court. He is also protected by them. They activate immediately. There's a process against him. So we are going to enjoy our rights at their convenience? Not today, Your Honor. That's all I wish to say.
He was assigned by the initial IO, who is an assignment in Mombasa. And that is why they did not write to the witness protection agent immediately. This is Sergeant Bashir. The other one is Chief Inspector Geoffrey Ndato.
You made a ruling last time you were in court. And what was remaining today was the terms and conditions on which the accused person will be released. At that point, the prosecution and the counsel watching brief are telling you to give stringent and strict terms. That does not exist in law. It is not anywhere. In fact, what the law says under Article 49 is the terms shall be reasonable. Let us start from there. So the issue of strictness and stringent does not arise anywhere. It is not based on any law. The reason that you are giving this bond is to ensure that the accused person comes to court. All the court needs to do is to ensure that the terms it gives are sufficient, yet fair, so that the accused person does not remain in custody. It's all a matter of fairness. But then you can see my friends here are cushioning the approach with some kind of blackmail. That because we have not reached out, or because we have not visited, or spoken, or helped to pay the bill, then they should remain in custody. Are we supposed to start paying so that then they can come back here and tell you, oh, they have paid, please let them go? It is some form of blackmail. We are not saying that ADR is not acceptable. It is acceptable, very acceptable. But let us not be cornered by it, and you're being told the terms of bond then should be in relationship to the fee that they're supposed to pay in hospital. That again, are they saying that that money that is going to be paid in case it's cash bill is the one that they are going to take and go and pay the bill? We can do this with some kind of soberness. We can do this with some kind of understanding. But now it has reached the time where the court now pronounces why it is giving particular terms. But then an affidavit is brought this morning. Prior to that, I was given statements which my learned friend from the DPP, Ms. Onunga, has taken back because they were not redacted, which I have seen it's okay. They have now brought an affidavit which has no prayer. It does not show what it's asking for, it's just telling you what they have done so far. So what is the reason for this affidavit? What prayer? What are they asking for? We were here last in court.
Engagement and the statements already made before court by the prosecution, and it indicates that Mr. Festus Kavuli Musyoka up to now has not spoken. He's been breathing through supplied oxygen for all those days up to today. And although he has shown a little improvement, he is still not in a position to give a statement. And his bill now has arisen to 5.7 million. I'd like to give a provisional copy, also to show my learned friend, Mr. Clifford Better. Unfortunately, I was not able to communicate with Mr. Clifford Better in the last 2 weeks through telephone till this morning. And there has not been goodwill so far to show the support of at least Zisa, who is detained in a hospital, and also my client Festus, who has now a very serious bill, most probably will be raised by the family. We are all hoping that he's going to recover, and we are hoping he's going to recover and will be able to give his side of the story. On the issue of witness protection, Your Honor, it is now a new jurisprudence. It is an act of parliament, and the Treasury has now funded its activities to seal up the gaps which have been there in the past and where witnesses have lost their lives. But unfortunately, Your Honor, it operates in secrecy for the protection of the witnesses who, in this case, are affected by the attempted crime. And they have a process till they assure court that they have secured the witnesses. Your Honor, what has happened in other courts in similar matters, in murder cases, in attempted murder, in serious crimes, corruption, witnesses who feel threatened. The accused persons have been detained, Your Honor, up to when these witnesses have been put under protection. That is what has happened in the 2 or 3 other cases currently, Your Honor. While we are in good terms and we are talking with his lawyer assures me that he wants to pursue that route also. It is the wish of the family of Festus Kavuli Musyoka that the accused person is detained till the witnesses are protected.
Expert report. However, we have it. He has received it this morning, and that has been taken over by events. What is pending is the report from the government chemist. And lastly, Your Honor, the IO is to record a statement from one prosecution witness who could not record his statement prior because he was unwell and he traveled to his rural home. Yeah, Your Honor, the letter is attached. And that is one of the reasons why we are not ready for pre-trial. And the second reason is that the IO was able to record statement from the 2 victims, PC Lawrence Muturi and Felicitas Ziza. However, P3 for Felicitas Ziza is not ready. She is still detained at the hospital because she has not cleared the hospital bill. The hospital is Medihill Hospital. And as per the direction of this court, Your Honor, the IEO made a request to Witness Protection Agency for protection orders to seek for protection orders for the victims. We have attached the letter. State that the Witness Protection Agency is on the matter. And he was advised not to serve this witness statement for the 3 victims until they are redacted, because that is one of the protection measures. On affidavit, he has gone to commission. My lady, I will serve the court in a short while. He was not able to record the victim, the statement from Festus Musyoka, who is still admitted at Nairobi Hospital because he is not able to talk. And we have a letter to that effect from a doctor at Nairobi Hospital. Felicitas and Lawrence, he's coming, he's going to commission his letter. The letter plus the affidavit.
I just wonder, why should people wait for courts, then start action? I thought I was seated in my chamber just comfortably thinking all this will be ready.
You apologize, my lady, it will not take long. Just give us like 15 minutes to be here. Just go to Your Honor, I've supplied some of the affidavits together with the attachment, the letter from the doctor. I will go personally to pursue the witness.
Any other matter prosecuted, you are not ready rather than just wasting my calories sitting here. You're not for just go back.
All the hearings, we are ready to proceed. For all the hearings,
We are ready to proceed.
yes, we are ready to proceed.
Okay.
All the hearings are.
Tafadhali kama ulikuwa unakuja mara ambayo tumeplace aside tupatie.
Former Cabinet Minister Honorable Cyrus Jirongo had a transaction 33 years ago of a sale of land. The land was involved with one retired, the late President Daniel Arap Moi. The transaction was completed 32 years ago. The state comes in 2016 and decides now to activate the charges because Cyrus Jirongo was not in the political camp of one of the parties in the 2017 elections. So in 2016, towards the end, 2016, Cyrus Jirongo's file is opened up They want to charge him for a criminal matter of a transaction that happened 32 years ago. Cyrus Jirongo moved to the High Court for Justice Odinga and got orders to stop. The judgment was in his favor, that was inordinate delay. The files had gotten lost. It was a politically instigated arrest and charging. The state, not satisfied with that decision, moved to the Court of Appeal, and the Court of Appeal vacated the orders of the High Court. The same day the orders were vacated, Cyrus Jirongo was arrested and he was charged. We did object for that charge because he had appealed to the Supreme Court, but still the court went ahead, the state went ahead, arrested our client, charged him, and was released on a cash bail of 200,000 shillings. The Supreme Court heard the matter and agreed with the High Court decision that was a proper abuse of prosecutorial power and the investigatory arms of government. Honorable Cyrus Jirongo's decision from the Supreme Court clearly said that the matters before the criminal court in the lower magistrates court be terminated. Today we appeared before the chief magistrate, the criminal court, Milimani, before Honorable Andai, and the charges have been terminated under Section 89 of the Penal Code because the charges were defective. The charges had no basis to lay their hands on, and the cash bail that he had deposited has been returned to him. This is a clear case of the zealousness of the DPP and the state to use their offices for political contestation. The day the Supreme Court made this ruling, it is very clear that now there are limitations in terms of instituting criminal proceedings. You cannot be investigated of an offense that was done some 100 years ago. The witnesses are dead, the documents are not there, the evidences are there. Therefore, this is a landmark decision where now we have that the state must institute charges within a reasonable time to allow the accused person get his witnesses, get his documents, and get his act properly. We are satisfied and we are happy on behalf of Honorable Cyrus Jirongo that justice today has been done and the political contestation shall proceed. Our client will continue campaigning as a presidential candidate. He has never stopped campaigning, and the criminal law should not be used as a way to deal with politicians who do not agree with the state or do not agree with the political establishment at the time.
How big was the land and its value?
The land is around near DOD. The value of the land at that time was some around 13 million shillings, but today the value of that land will be astronomical. I'm not a valuer, but the land will be very, very astronomical. The transaction of documents are no longer with us this time.
How many acres?
It was around 2 acres, near DOD. Any issue?
What did Adai say in his final pronouncement?
Chief Magistrate Andai only echoed the decision of Justice Odinga. He quoted in verbatim that he has been prohibited, him, the agents, the state, and anybody from proceeding with that matter. The matter is dead ab initio. Therefore, Honorable Andai has put his pen down and said that he has no movement other than to comply with the decision of the Supreme Court. Thank you.
You know, I do appear for the accused person in this case. Mr. Manzo, Honorable Manzo was here. You have to call him brief for the victim. Ms. Sonunga is the court. Is that okay?
Good morning, Your Honor.
Yes, maybe as we wait for his advocate, we can visit that site so that we take a convenient date that will be convenient to his advocate also.
How long should we wait for him?
1 hour.
No, we can't wait for 1 hour. The court is not congested, so I have to deal with mentions to clear courts. So I'll just give a hearing date. And where is Ayo?
The Ayo is the court. You are like confirming that our prepared document is ready.
Mwahome Mwangi, Anne Duta Ruo, Juliana Jahenda Makar, Samuel Murimi Ireri, Grace Wamboi, Lawrence Kimaru, Irene Wamboi, David Ruben, and Rapid Medical Services Limited have been jointly charged with conspiracy to commit an offense of corruption contrary to Section 47A3 as read in Section 48 of the Anti-Corruption and Economic Crimes Act number 3 of 2003. Accused 9 and accused 10 faced a second count of fraudulent acquisition of public property contrary to Section 45(1)(a as read in Section 48 of the Anti-Corruption and Economic Crimes Act of 2003. Each of the accused persons were represented by advocates who made passionate submissions supporting the position that the accused persons be released on reasonable bond or bail terms based on the special and peculiar circumstances pertaining to each, being, among others, their specific stations in life, that the fact that they are not flight risks, the fact that they freely submitted to summons by the DCI, the fact that they played a minimal role in the offense, and the fact that they personally presented themselves before court. Reference was also made by counsel to the bail bond policy guidelines, and of note is that the prosecution did not object to the granting of bail to the accused persons. Now, the submissions were made, and to To support their case, counsel, led by Senior Counsel Ojienda, relied on various authorities. I have listened to all the presentations made by the defense counsel as well as the prosecution thereto. Now, the jurisprudence surrounding the grant of bail or bond is now settled law. The rights of an accused person are firmly entrenched in the Constitution of Kenya. Article 49H highlights the aspects of bail, to wit, that an accused person is entitled to be released on bond or bail on reasonable conditions pending a trial, unless there are compelling reasons not to be released. Section 123A of the Criminal Procedure Code gives the parameters for grant of bail, which includes, among others, considering the nature and seriousness of the offense, the character, the antecedents, the associations, etc. of the accused person, among other considerations. Now, this court is truly under a duty to consider the impact and seriousness of the offense, but even amidst all this, must find a balance so as not to trump the accused's constitutional rights. Now, the offense in question is conspiracy, whereby an amount of 27 million shillings was involved, which amount is not small by any standards and cannot be wished away by the sleight of hand, given as these are public funds. However, the court has always reiterated that a balance must be maintained to ensure that there is public confidence in the administration of justice, or rather that public confidence in the administration of justice is maintained on the one hand, and that the rights of the accused persons to bail are also not unreasonably denied. Mativo J in Republic versus Danford Kabage Mwangi, that is 2016 ELR, observed as follows: granting bail entails the striking of a balance of proportionality in considering the rights of an applicant who is presumed innocent at this point on one hand and the public interests on the other. Now, on the particular argument as to why each of the accused persons' bond terms should be considered differently, I have looked at the authorities cited, and among them I'm considering the Anti-Corruption Case Revision 12 of 2019, that is Ruben, Maruben, Lemunyete and others versus Republic, where Judge Mumbi, as judge of the Anti-Corruption Court, as she then was, at paragraph 60, reiterated that each person's case and each person's entitlement to bail or otherwise to bail must be considered and examined on its own facts and merits. And the accused person's personal circumstances must also be taken into account. In the end, I have considered the personal circumstances of each of the accused persons appearing before me as indicated by counsel. Their bond applications. So we are talking about how many reps? 4 reps. 4 reps for each packers. Yes.
Mr. Mutembei, and he has not received witness statements as well. So I don't know whether each of us should supply 1 rib, 2 ribs, 3 ribs, so that we know how to do this. But I thought they should fairly give us. The government should be able to afford to pay. Yes, please. So that we have the statements.
Between tomorrow,
the prosecution intends to have the purposes of
number 1, that all the accused persons, that is accused number 2 through to accused number 9, will be released on bond. Secondly, Each of the accused persons will be released on the following terms. Accused 2 and 3 to be released on a bond of 2 million shillings with one surety of a similar amount, or be admitted to cash bail of 1 million shillings. Accused 4, 5, 6, 7 and 8 to be released on a bond of 1 million Kenya shillings with one surety of a similar amount, or a cash bail of 500,000. Accused 9 and 10 to be released on a bond of 3 million with one surety of a similar amount, or a cash bail of 1.5 million shillings. There will be a mention for compliance on 9th of August, as had earlier been set by my learned brother, Honorable Mugambi, and those are the orders of the court.
Your Honor,
bail is not opposed and the accused are not admitted to bail. Each is ordered to be released upon executing a bond of Kenya shillings 500,000 plus one surety for like amount. Or in the alternative, each may be released upon depositing the sum of Kenya shillings 75,000. I have to agree with the advocate for the state that their status as accused persons is different, distinguishable from their status rather as suspects when they were in investigation. I think on that basis, I will slightly enhance the terms they were given in the further, as prayed, the accused persons are to refrain from making any contact with witnesses in this matter. As public officers, Section 62 of the Anti-Corruption and Economic Crime Act comes into force, and they stand interdicted. I think a letter will follow, the operation of law until this case. Further, they should refrain from leaving the court jurisdiction without the leave of the court. Those are the terms that you have. You have understood that
jurisdiction, so it would be back and forth. I wish that's the reason why we are making that end of observation. But it's okay. From the moon here, it have been done.
These are 2019.
Yes. Yes.
Anyway, it's been brought to court today, so I think we'll just deal with that. We'll have to get knowledge about the documents that are supposed to be or rather,
it's okay. Your Honor, these are charged accused persons.
With regard to witness statements,
yes,
and documents that we are going to rely on,
yes,
the accused persons or their advocates,
yes,
are advised to go to ESCC,
yes,
and obtain the same so that they can sign an inventory,
yes,
to prove that they have taken the same. Sorry, I'm trying to get the timeline.
Your Honor,
It
would normally be 2 weeks.
Yes,
from today.
within 14 days.
Because we should hold a conference official within 14 days from today.
Yes.
So that should be the timeline in the first place.
I don't know. This practice of
Did you understand what we are saying? Yes, that's good. Presented. You've heard everything that has been said. Yes. Any reaction you have to all that? Is there anything you want to say in relation to what has been said by the advocate for the state and even the other advocates appearing for your court? Is there anything you want to say about that?
Your Honor, the record will attest that virtually you were told that the accused tested positive. You gave directions. The accused appears with his counsel before you physically. We did appear. Counsel explained the absence of the accused as being due to a positive COVID test at Aga Khan Hospital. A document to that effect was presented to court. I challenged the document on the basis that I've done more than 5 tests at Aga Khan for COVID. The court ordered a verification to be done. The report has been given by the investigating officer that the accused never did a COVID test at Aga Khan. He never gave samples for COVID. He never was given a sick off from Aga Khan, save that there is a narration in the doctor's report that he claimed to have tested positive at Coptic. And on the basis of you not issuing a warrant of arrest was on the strength of a medical report of COVID positive from Aga Khan. I completely associate myself with the state. This court was taken for a ride. It was misled intentionally. Any attempt to cure that by bringing a document from Coptic now is only raising more serious issues. The alleged Coptic document is older than the Aga Khan document. What stopped counsel or the accused from giving the court the document of COVID? Is this document now having been produced to you, Your Honor, a generation specifically to cure the steps that were taken to mislead this court? Your Honor, it is my humble submission that the accused has been dishonest. The document presented to you is not a document that the court was to rely on, and we urge the court to cancel the bond and the bail terms for the accused person. He proceeds with his case while in custody. May the court get favor in us. For judicial purposes, I've just been in court here, and this is the second investigating officer's report on people claiming that they are COVID positive. This type of narration must come to an end. COVID is a death sentence. It shouldn't be taken lightly. Trials are being adjourned by people alleging that they have COVID. Your Honor, we urge this in order to serve a message to very many of the accused people peddling such rumors. Your Honor, we urge the court stamps its feet and puts an end to this narration about a medical pandemic, which we should be sorry about.
Prosecution is not objecting the granting of bail, stroke bond. However, we are praying for enhancement of the same, now that the persons were formerly suspects but are now accused, and therefore the status has changed. We are therefore praying for enhancement of the bail term to compel their attendance. We are also praying that they be prohibited from contacting any of the witnesses in this matter. And to also not leave the jurisdiction of courts without the authorization of this honorable court.
And the police station. This time round, Your Honor, you consider the nature of the offense, you grant them lenient bond terms. And plead, Your Honor, you can give the same bond term. The investigation you see since 2019, and they have been diligent yet attending to the investigating officers' summons. They will not be
Any objection to bail?
Your Honor, we have no objection to bail.
Any submission?
Yes, Your Honor, we submit that you release the accused persons to admit them to bond and hotel them cash bail. Your Honor, they have been on cash bail of 50,000.
On the 8th day of March at Joska Shopping Center within Machakos County, being a person employed by a public body to wit, Ministry of Interior and Coordination of National Government, as Chief Kenya location, received a bribe of Kenya shillings 40,000 from Peter Mukian with intent that, in consequence, he would release his 8 head of cattle held at KBC police station. Tell us the true or false. Count 4, abuse of office contrary to section 46 as read in section 48(1) of the Anti-Corruption and Economic Crimes Act number 3 of 2003. Teras Ndambuki on the 8th day of March 2019 at Joska Shopping Center within Machakos County, being a person employed by a public body to wit, Ministry of Interior and Coordination of National Government, as Chief Kenya location, you used your office improperly to confer a bribe of Kenya shillings 40,000 upon yourself, which comprised of money obtained and received from Peter Mukian so as to release his 8 head of cattle held at KBC police station. Is that true or false?
False. It has entered a plea of not guilty.
Charity Nyawira. Charity Nyawira. We called for the attendance of the IO in this matter.
She was having tested positive at Aga Khan Hospital. So that was dishonest. We are being told now about another hospital.
I swear by the Almighty God that the evidence I shall give before this court touching the matter in question shall be the truth, nothing but the truth, so help me God. Your Honor, number 101588. Corporal Trufus Adoyo. Station at DCI Central, the investigating officer in this matter.
Your Honor, following the directives that were given on 27th of last month, we did a letter, Your Honor, to Aga Khan University Hospital, where from AK5R, that is a radiology department request form, purported to have originated. Your Honor, the letter was received and the response to it was that the accused person before this matter was in that facility on the 14th of July where he complained of shortness of breath. Of 1 day history, Your Honor. Your Honor, the tests were done by the medical staff. HRCT test, which indicated that there was no evidence of pneumonia or acute chest findings. As per the request form. Your Honor, the same facility also confirmed that they are not in a position to confirm to this court whether the accused person tested COVID-19 positive or not, because he did not take the test in that facility. This is because when he arrived in that facility, he mentioned to the medical staff who attended to him that he had tested positive in another facility, that is Coptic Hospital. But he did not provide any certificate to confirm the same.
The report that came that the document is forgery. It's not a forgery. The hospital has owned it up. That Raila presented test results from Coptic on the basis of which that narration of that document was prepared. I have come and my client is before you. I have presented the origin of the document which purportedly alleged to be fake, and which has been confirmed to have originated from Aga Khan Hospital. And the test result that was taken from Coptic. We even have the original receipts. So the issue about verification, the issue about honesty and dishonesty, I think that is made part a lot of bad. And I want to underscore that my client has always been available. It is not, even when you talk to us, the counsel is not an expert. And I want to, with the tremendous respect,
that's only an interpretation you know of the document before.
You cannot call me dishonest. We owe a debt to this court. The document that my client presented to me is what I presented to him.
The same documents have not also been verified. It is quite unfortunate that we entirely leave this matter to the court. Now that it is indicated and confirmed that we never took any COVID, is the document that is already in court file. That is the document that was subjected to verification. And you see what he was presenting is a narration to the doctor. And now he comes with that narration to claim that he was positively on. I mean, we are living at a very sad time when advocates and accused person who owes duty of honesty to this court
because of what is said in paragraph number 3, I wish to then present to the court both the original of this document, which Colonel has confirmed that was originated from the hospital as found in paragraph 2, which Mr. Mari was making a lot of noise about, that it was a forgery. That document has come from the hospital, they have confirmed it. It was originated from the hospital. We also want to give the court the original test and the certificate taken from Coptic Hospital if the court needs further verification. But my client is here. I told the court that it is available from 30th. And we are here. And even on that day, it was before you virtually. If I may, I have looked at the letter.
In this matter, I came to an issue for verification.
Morning, Madam. My name is Dan Stomach. I do work for the funds.
You know, O-U-M-A.
Oma.
Yes.
You've been served with a copy from the Kenya University Hospital?
No, I don't have it.